So when you start out in your business dealings with another party, what are you trying to accomplish? At the end of the day, if everything goes well, what do you hope to get out of your agreement with the other party? So you want to start with the scope. The scope is one of the most important and certainly an essential term of any contract. What is it that you're going to do, and what is it that the other party is going to do? And keep that in mind and make sure that is spelled out clearly in your agreement, and determine up front what you want to happen at the end. So begin with the end in mind. Try to predict the future as best you can. You can go to that. Thank you. A number of you are probably familiar with letters of intent, and I believe some of the study guides that you all use refer to these documents. The letter of intent is a document that outlines a desired deal between parties that they later on will formalize into a legally binding document. And they're commonly used as negotiation tools, but they're, in the world that I live in, until you have a signed contract that lays out all of the essential terms, it's not an actual agreement. And may not be binding. So you want to try to, if you're going to use letters of intent, make sure that you follow those up with a formal written agreement to memorialize all the essential terms, which may or may not be in your letter of intent. Again, this goes back to whether or not you actually have an agreement. And when it comes to letters of intent, courts are going to consider several factors to determine whether they are in fact enforceable. One of the important things is the number of terms that you all agreed on. What details are in there in a particular agreement between two parties in their business? Are all of those key terms that you usually see in an agreement, are those spelled out in the letter of intent? If they're not, and a court determines that those are essential terms and there was no meeting of the minds, then the court isn't going to find that letter of intent is a binding document. Again, best practice, avoid relying on any sort of letter of intent or any sort of oral agreement. Push for a final written contract. This is just an example of one case in Florida, a case that was decided in 1998, where there was a letter of intent, and it basically said these terms and conditions are acceptable, but they will present a more detailed and formal purchase agreement later on. That formal purchase agreement was later contested, the letter of intent was contested, and the court found that because there was this agreement that the parties would later agree to more specific terms, it wasn't an enforceable contract. So these are some contract provisions that most of you on this webinar are familiar with to some extent. These are certainly some essential terms that you would want to make sure you have covered in your contract. Obviously, payment being really important, right up there with what you're going to do and your scope of work. Change orders in the construction world, those are just mini contracts. They are additions or deletions from the original contract. Your liquidated damages are damages provisions that you sometimes see in contracts where the parties are really unable to come up with an exact number on the damages that another party will incur if the other party doesn't perform. Force majeure, that's a really vogue provision these days in light of the COVID-19 situation and people's inability to go to work, perform contracts that before they signed them, when they signed them, they were planning to complete within a certain period of time. Because of the events going on in the world right now, they haven't been able to. Indemnification, that's a fancy term of if I'll put it in these terms, if you do something that damages me, or I do something that damages you, the parties try to shift the risk to make one party responsible for those damages, and that party may not be the party that actually caused the damage. So you need to be paying attention to that risk shifting mechanism. And of course, termination, which comes in various forms, and then your dispute resolution, where the parties are unable to reach resolution and have to seek court or arbitration involvement. So payments are a essential term of any contract, and those can be broken down in various forms through a schedule of values, which lists a particular scope of work and assigns a dollar value to that. And then in the construction context, if you use that as an example, a party will bill against that schedule of values as a percentage of completion of that work. You can also have a cost plus or a lump sum or a time and materials payment component or a unit price and allowances. There's also, go back one slide, please. Thank you. There's also the timing of payments. You want to make sure that that's spelled out in any good contract. How often are you going to get paid? When will you get paid? What do you have to do to get paid? Whether it's a progress or partial payment or a final payment. Also, be cognizant of contingent payment provisions in your contracts. Those are known as pay when paid or pay if paid provisions. And what that is for those of you who don't know, those are risk shifting provisions that basically say, I don't have to pay you unless the person who's supposed to pay me pays me. And that can leave you twisted in the wind a little bit. So you want to be paying attention to that to make sure if you can avoid it. If you're the party downstream, you want to try to avoid a pay if paid provision. You want to get paid for your work, within a certain period of time of when you do it. So the difference between pay if paid and pay when paid, I've cited a case here, a pretty famous case in Florida in the construction context, but there has to be very specific language in your contract in order for a pay if paid provision to be enforceable, because courts don't like to enforce that kind of situation, because if you've done the work, you should get paid for it. You shouldn't have to wait for some contingency to occur in order for you to get paid for your work. So with a pay if paid provision, it basically says, I don't have to pay you unless and until I get paid from the party who owes me money. That needs to be specific. It's a condition precedent to payment to you in that example, but that needs to be clearly written in the contract. It has to clearly express that the contractor will be free of any obligation to pay if not paid by the owner. Pay when paid is a different provision, and that still requires, in this scenario, the general contractor to pay the contractor within a reasonable period of time. Again, it's better to have, when you have payment provisions in your contract, best to spell out exactly when those payments will be made, that they're not conditioned on someone else paying that person before they pay you, and what you have to do in order to get paid. A good contract will spell out all of the conditions that need to be met before payment is made. Change orders. Deal with those all the time. They are mini contracts, and they can change the contractual requirements. There are usually contractual requirements that spell out how a change order can be executed, how it's enforced. A lot of times it will require the parties to both sign it and only certain people to sign it. So you want to be paying attention to what the contract provides in terms of the enforceability of those change orders. I've had situations where someone makes an argument that the person who's supposed to sign the change orders never signed them, therefore they're not enforceable. Or even though the party authorized the work to be done, it wasn't authorized in writing, which is what the contract required. So they argue that they don't have to pay for that work. So just be careful, understand what needs to be done in order for a change order to be enforced. I realize that in fast-paced projects and the day-to-day world that we live in, it's not always possible to get all the I's dotted and T's crossed when it comes to change orders, but you need to try your best. Even if you can't get someone to sign the change order, or they've authorized you to do the work, because of some reason they just can't sign the document, at least follow it up with an email memorializing the directive. That's better than nothing, better than simply going ahead and going forward with the work without anything more, and then hoping at the end of the day you get paid without a written signed change order. Most contracts will say that those change orders, there's a process that you have to follow. So just make sure that you understand what that process is. And if you can't follow it for whatever reason, you need to have something in your file going to the party who's authorizing the change order, memorializing that agreement. Because in the world that I live in, if you don't have that, then it's a he said, she said situation, and that's where it gets expensive in litigation. Liquidated damages, I mentioned that earlier. This is a specific sum of money that one party can collect if the other party breaches the contract. It can't be a penalty, and it has to be a situation where the actual damages are not readily ascertainable at the time of the contract. And it can't be that liquidated damages number is so grossly disproportionate that might actually flow from that breach. So just keep in mind, you can't just arbitrarily assign some number to a liquidated damages provision, because courts will scrutinize that. Hopefully, if you're putting together a liquidated damages provision that you're trying to enforce against another party, there needs to be some thought process behind it to try to meet the objectives that the Supreme Court says you need to follow in determining whether that provision is enforceable. Force majeure, fancy French term, but it's pretty poignant these days, and certainly I've had a number of cases where I've had to look at this provision in a contract to see whether or not there is any excuse based on COVID-19 and the situation that we find ourselves in here. But basically, these are excuses to contractual obligations that are beyond the party's control. And they list certain triggering events such as acts of God, floods, hurricanes, wars, strikes, certain accidents. I will tell you that some of the force majeure provisions that I've read do not have language that would excuse the world events that we're dealing with these days. So you might, depending on where you are, you might want to take a look at your contract if you use a form contract, and make sure that you have the types of events that we're dealing with these days: pandemics, government shutdowns, government orders, covered by your force majeure provision. Because if you're the party who is trying to say, I can't complete my project because I can't get anybody into work because of COVID-19, or government's not allowing us to do work, you want to make sure if you don't have that in there, you add it for your contracts going forward. This is a similar slide to what I was just mentioning in terms of how force majeure provisions are interpreted. They are going to be narrowly interpreted, and you need to make sure that the issue that you're saying is a force majeure provision is actually covered by your contract. And unlike many states, Florida does not limit force majeure provisions to unforeseeable events. So you can contract for other types of events. So I would encourage you to, if you're using a standard form contract, I would encourage you to take a look at that force majeure provision and revise it as to cover all types of events, including those that we're dealing with these days. So again, analyze your contract: pandemics, epidemics, diseases, acts of government, national emergencies. I saw someone had put up on the screen hurricanes. Yes, you can put all of that in there, and you'd rather spell it out and then have to litigate it after the fact that the certain event, even though it wasn't specific in the provision, should be covered. You'd prefer not to be in that situation. So take a look and make it more broad if you have that leverage with whoever you're contracting with. You may or may not, but it's worth taking a look at. Impossibility of performance. This is a fancy legal term that discharges a party from performing a contractual obligation which is impossible to perform, and that the party neither assumed the risk of nor could have acted to prevent it rendering the performance impossible. And it has to be objectively impossible, not just difficult or hard or burdensome for that party to perform. So examples, weather conditions could be hurricanes, natural disasters, hurricanes. Government passes a law making the performance illegal. So for example, you might have a situation where you're building a project and the government is not allowing any workers to be in the building, not allowing any inspections to be performed. Stolen or destroyed property, or one of the parties is injured and can no longer perform the duties identified in the contract. A party raising this defense must prove that the unforeseen event occurred, i.e. COVID-19. The event made performance impossible, and the parties could not have foreseen the event when signing the contract. That last one is tough, because you have people will make the argument that, well, something like this was foreseeable, or a hurricane was foreseeable, bad weather was foreseeable. But those are the three things that you're going to have to prove in order to raise that defensive impossibility of performance. Frustration of purpose, another defense to a contract claim. It provides a defense for further contractual performance if the purpose has been frustrated. It's limited, though, to cases where performance is possible, but an alleged frustration, which was not foreseeable, totally or nearly destroyed the purpose of the agreement. And if the purpose of the contract is completely frustrated by the coronavirus pandemic and outside the party's control, then a party could have an excuse for non-performance based on the frustration of purpose doctrine. Indemnification. The indemnifying party is going to reimburse the indemnified party from losses, damages caused by the indemnified party. It's all you need to know about this is it's a risk shifting mechanism, and it can be imposed either by law or contract. And in the construction setting, think about it from this perspective. So a general contractor, with some exceptions, and we'll get into that in a minute, wants the subcontractor to handle, defend, pay for claims that the subcontractor causes, certainly. But sometimes there'll be situations where a general contractor will try to hold the subcontractor to problems that other parties have caused, or the general contractor has caused in whole or in part. And so that's a very nuanced area of the law, but that does happen. And what the general contractor in that scenario is trying to do is shift the risk to the downstream parties, the folks with less leverage. And if those types of agreements are valid, if written correctly and certain things are followed. The other thing to keep in mind is a well-written indemnification provision in a contract is not only going to speak of indemnity, but it's also going to speak to the duty to defend, which means that party has a requirement to defend against any claims, not just pay for those claims. So there is a difference. And defend meaning if there's a lawsuit or other dispute resolution situations, the party who is doing the indemnifying will have to defend the other party as well. This statute 72506 specifically deals with construction contracts. And when in my general contractor example, when the general contractor is trying to push liability to the subcontractor for things that the general contractor may have done incorrectly, that provision is going to be void unless it has some bells and whistles on it or in it that comply with 72506. There needs to be a monetary limitation on the extent of that indemnification that bears a reasonable relationship to the contract. And if there are project specifications or bid documents, this requirement to indemnify the general contractor for its bad acts will need to be in those documents. Termination, another thing to look for in your contracts. Make sure you understand how that works. Obviously, that's typically that's stopping the work before it's performed, although sometimes there will be termination provisions in the contract that just operate by their own, by the time period in the agreement. The contract terminates on its own after a certain period of time. But you need to be aware of the notice provisions that are required if you're the one or receiving a notice of termination or you're the one providing it. Typically, there are two types of termination provisions. There's one for convenience, which allows the owner, someone upstream, to call the contract quits, and regardless of whether the party who's getting that notice of termination has done anything wrong, that's called the termination for convenience. You want to make sure that your contract spells out what happens in that instance. What will you, if the general contractor or the owner is sending you a notice of termination for convenience, what are you entitled to get paid for in that situation? There's certain situations where depending on how you're getting paid for your work, you'd want to get paid, of course, for all the work that you've done up to that point. But you want to add in your contract that you get your profit on the work that you haven't performed. That seems fair. I can tell you I've negotiated both sides of that, and if you're the party who's being terminated for convenience, you've prepared, you've budgeted for that project and the profit that you were going to earn. So it's fair game to ask for profit on work not performed. If I'm the party terminating, I'd say, no, I'm going to pay you for what you've done to date. I'm not paying you any more than that. I have that right. So pay attention to that. Obviously, the termination for cause, that goes without saying. That's when someone hasn't performed properly. But please note in your contract, what kinds of notices have to be sent. Is there a scenario where you have to give notice and opportunity to cure the default before you terminate? You don't want to be on the wrong side of an improper termination. So make sure you read your contract to know what those conditions are, what those notice requirements are. Most good contracts will spell out that the notice, whether it's with an opportunity to cure or termination, will say who it needs to be sent to, how it needs to be sent, when it needs to be sent, all of those things. So make sure you're aware of that. The types of damages that are recoverable in termination, those should be, to some extent, spelled out in your agreement, but some of those things are overhead, value of the work that you performed, lost or anticipated profits, and incidental or consequential damages. Most good contracts will speak to the monies that you can be paid if there is a termination for convenience, as well as a termination for cause. A lot of contracts will have some sort of mutual waiver of consequential damages. So just be familiar with those types of damages that you can recover or that may be assessed against you for a termination. Dispute resolution, that's where you go to get contract disputes resolved when they can't be resolved through the management channels or employee channels. Well-written contracts will have something that speaks to where do the claims go to be resolved. There ought to be something in the contract that speaks to where the lawsuit or the arbitration will take place, whether there is a waiver of jury trial, and all those things, so parties aren't hiring lawyers to argue to judges that the case should have been brought here, but it was brought there. You want to have something in your contract that speaks to these issues and how they get resolved when they can't be resolved through the management channels. The initial decision maker, for those of you who are familiar with the American Institute of Architects contract documents, that's part of the AIA forms. in some contracts. You can also have a dispute review board. Some contracts will have a condition precedent where the parties are required to go through mediation before they arbitrate or before they file a lawsuit. And then, of course, there's arbitration and litigation. So just the takeaway from this is you ought to have something in your contract that speaks to how claims get resolved, and then just make sure you know the general process, because odds are when it gets to the point where you're looking at these issues, you probably already have a lawyer involved who's going to be hopefully well-versed in knowing where a dispute needs to get resolved. Next slide, please. So this presentation has been focused on Florida law, and in Florida, you can only get your attorney's fees if there is a contractual provision or a statute that allows them. And so depending on the size of the deal and how things might end up, again, begin with the end in mind. If you're dealing with a contract that's, a few $1,000s, you're probably not all that concerned with attorney's fees. But if something goes wrong, even in a contract like that, and it could end up costing you a lot of money, if you get into litigation, you need to consider whether or not you want to have a prevailing party attorney's fees provision. Because if you don't have it in your contract, and unless there's a statute that specifically addresses the claims that you're raising, you're not going to be able to get those attorney's fees. And keep in mind that there is case law in Florida where even though you may have a prevailing party attorney's fees provision in your contract, it's not automatic that a court is going to do that. There is certainly case law out there that courts have determined that there was no prevailing party, which is a hard conversation to have with clients, because there has to be a winner and a loser in most people's minds when they go to litigation. They go through a trial, but some courts have found that because of some circumstances, there was no prevailing party because this party prevailed on some claims, this party prevailed on some other claims, and the court ended up saying nobody is the prevailing party, so there aren't any fees to be awarded. So just keep in mind that even if you have a contractual prevailing party attorney's fees provision in your contract, it's not automatic that you'll get them. But I would strongly encourage you to take a look at your contract, think about what you stand to lose if someone ends up breaching the contract. Litigation is expensive, so I would always want a contractual prevailing party attorney's fees in my contracts for my clients. That concludes my presentation. I don't know if there's any other questions. Glad to answer them though, and I appreciate the opportunity to speak with you.
Thank you very much. I don't have a lot. I do have some questions about penalty, and I'm not sure, Tom, if you want to elaborate, but maybe, I don't know if we can go back to that slide or if you want to just talk about it in general.
Sure.
The rest of you, I'm sorry, before we get started, for the rest of you, if you do have questions, if you would type them in chat, that would be very helpful for us to be able to kind of manage them all together. Thanks. Alrighty, I don't see any new ones, so let's start with penalty. And just maybe if you can give us a little bit more summary on penalties and how that works. And I think it popped up pretty early in your presentation.
Yeah, let me get to bear with me for just a second. Yeah, so the liquidated damages provision section that we were talking about. So I think what we're talking about here is, in the context of delays on a project, and an owner, let's just use the owner general contractor example. The owner needs to get, I'll just use a school as an example. I have clients that build schools, and they need to have they need to have a school opened by a certain date. And so what they try to do is, if they don't open the school by a certain date, what is that going to cost them in rental space? They got to find a new venue to house the school while the work is still going on. So they try to figure out a reasonable number that they can put in there for their liquidated damages. So if the project isn't delivered on time, that they can at least recover that. It may involve, finance charges. If the project isn't finished, the loan isn't closed, what is that going to look like for the owner? And so you just try to you do the best you can to estimate what those damages are, but they can't be. You've got to build some contingency in there, because you're not going to know everything at the time that you're contracting if the contractor in this example doesn't deliver the project on time. I've seen liquidated damages be couple $1,000 a day. I've seen them be really high. It just depends on the type of project that you're dealing with. And so you just have to try to do the best you can if you're the owner in that situation, and estimate what your damages are going to be if it's not delivered timely. So you'd want to sort of memorialize that, make notes of that. How did you arrive at that figure if you ever have to defend it?
Thank you. And Tom, let us know if that covered it for you. We do have some intriguing questions that have come out now. One was a really good one. What is one of the most interesting cases you've represented, and what was the outcome, if you're allowed to say?
Interesting case. Okay. Well, if I can go off topic, it is a contract related case, but it was really an interesting case. It was actually in bankruptcy. I represented a lender who had loaned money for two people's student loans. Mm-hmm. And those folks were trying to discharge those debts through bankruptcy. And we, of course, didn't want that to happen. And there was we had some good case law on our side. This is many, many years ago. But it was a very interesting case. And the reasons why these folks decided they weren't going to pay my client for the loans that my client had provided to put them through school. But we had filed a motion with the court to get the case resolved. It's called summary judgment motion. And the court did not grant it until the day of trial, So we had prepared to try the case. We were sitting in the courtroom, and before we got going with the trial, the judge granted our summary judgment. So that was a really interesting one. I've not had that happen before or since. But lots of other good stories before and after that. But that was an interesting one, just because of the facts of the case and what ended up happening at trial.
Interesting. Awesome. I have a few more. One has a great example of someone who, I'm going to say, inherited a contract from someone who left the company, but they didn't spell out the service level agreements. So the vendor said, hey, here's the email where we negotiated those SLAs, but it isn't in the signed contract. Is the email legally binding?
So you have just make sure I understand the facts. So someone sends an email that has terms that they're wanting the other side to agree to?
I think that's it. Yeah, it's service level agreements. If you don't do this in this amount of time, then there's a penalty or something, is how I know of service level agreements. And so it wasn't written out in the contract.
Yeah, I mean, so you can have, you don't have to have a formal document that says contract for you to have an agreement. That's absent some exceptions, you don't have to have something that's signed. There's something called the statute of frauds, which I won't get into, but let's just start from the proposition that if someone sends you an email and says, I'm going to do A, B, C, D, and E, and you're going to pay me X to do all that work, is that agreeable? And you send back an email and you say, yes, we have a contract. Not the way I would advise my client to do it, but so if in that scenario, if you have someone who has sent something via email, and absent some exceptions, the statute of frauds, but and someone responds back, yeah, we're good, go forward, we're in agreement. Yes, you could have an agreement there, certainly.
Interesting. Okay. And then Janine, if you have a follow-up, feel free to type it in chat. So Susan says, when does a letter of intent actually become binding? She was surprised by that. She thought it was only a document to identify general terms of scope, schedule, or cost.
Well, it becomes binding when a subsequent contract's not signed, and the other side who really wanted it didn't get what they want, so they make an argument that the letter of intent is binding. It becomes binding, as I'm trying to instill in my listeners here. The letter of intent is a preliminary, sort of we're talking about doing business. Here are the general terms, and it should be formalized, followed up with a signed agreement that memorializes all the terms. However, if in that scenario you don't end up getting to a written contract for whatever reason, if that letter of intent encompasses all of the essential terms that a court thinks that a contractor and subcontractor would have agreed to, you could have a binding contract just based on the letter of intent. So normally it's my experience, letter of intent's high level, conceptual. There are some essential terms in there, but they're not all in there. But if somehow, some way they get into that letter of intent and it does contain essential terms based on the industries that we're talking about, yeah, that can be your agreement.
Gotcha. All right.
I saw an email. Somebody chatted in. Are the terms proposal and letter of intent interchangeable? Mm-hmm. Maybe. I mean, normally a proposal is something that it spells out what one party is going to do, and it may or may not have a place for another party to sign. They're similar. Typically, they are different, though. Typically, you see it's clear that it's a letter of intent. Both parties sign. The proposal typically is coming from one party on their letterhead and is going to somebody to outline what the work is going to be. And then, depending on how formal the two parties are, the proposal may or may not make its way as a contract document. It just serves as a framework for it, but it also might be included as an exhibit to the contract.
Okay. Now, Connie is remembering back to our PMP practice exam, and we had quite a section on contracts, and she's recalling this and saying, if the contract is fixed priced, that did not specify anything about participating in meetings for discussing and resolving issues, is it permitted to add that to the contract? Are there limits to what can be addressed in a change request? And she said sometimes a conversation conveys ideas more quickly than email chains. So, talking about, can we add meetings to discuss and resolve this? Because sometimes just emails back and forth aren't great.
I'm just reading the chat here. Give me a second.
I don't know if I'm summarizing it well, but.
Well, if the original contract doesn't speak to, if what we're getting at is charging additional monies to attend meetings to resolve issues or whatever the scenario is, you're going to have a hard time getting compensated for that. Mm-hmm. If you think that, it's always hindsight 2020 sometimes in these situations, but if you think that if that's a client that's going to require a lot of meetings, you just want to make sure you either increase your fixed price or you have something in your agreement that speaks to being compensated for that. But if it's not in your agreement that you would get compensated over and above the fixed price for these types of things, then you're probably not going to be able to get it.
Yeah.
Because the contract is the contract is your manifest, so to speak. And if it's not in there, if I'm on the other side, I'm going to say, look, you're not entitled to that. We're all, and notwithstanding that, we're all trying to get something resolved, and now you're going to try to charge me for that. So best thing to do is include it as an extra in your contract. The fixed price does not include any meetings or whatever it is that you'd be doing here. Sometimes agreements will spell out, some of you may have seen this, where our fixed price includes 5 meetings. Anything over and above 5 meetings is going to be an extra charge of whatever it is. And certainly if you want to be compensated for that work and have the ability to write that in your contract, be as specific as possible in terms of what are you going to charge for that. So then at the end of the day, if you have 10 meetings and you think you're owed $5,000, but you don't have anything in your contract that says how much you get paid for those meetings, what are the odds you're going to have an argument with the person who's supposed to be paying you about how much they're supposed to pay you? Pretty good, probably.
Right. And would they be likely to address that in a change request? Hey, I'd like to add some meetings so that we can work on this.
Yeah. I mean, you can try it. Again, it depends on what the contract says about what is covered or you're able to use a change order for. I've not seen a lot of contracts where parties are submitting change orders for additional meetings. So it would be, it's not that it doesn't happen, because some of these contracts only allow for so many number of meetings, but generally speaking, it's not very common to see people asking for that additional money in the world that I live in.
Okay. And if anybody knows of anything else or wants to clarify that, we would be interested in that.
Yeah, kind of to Sharon, I was going to say, I kind of deal with this a little bit because I live in the world of contracts, and we don't do it from a context of adding just meetings, but we add in what the results of those meetings are going to be into a client deliverable term. So it might be that we're doing requirements documentation that we want to add, or something to that effect that shows the value to the customer, because a meeting isn't something that the customer is really going to want to pay for. They're going to consider that to be something that is your cost of doing business, if you will. But if you set it up as what is the end result of having those meetings that the customer's going to get, risk mitigation or whatever the end result is that you're having those meetings for, that you can, if you can put it in terms of what they would value, then you can do that change order that he referred to, and the customer's going to be more, at least I'm going to listen to you, maybe, at least listen.
Yeah, that's a great point. Yeah, I mean, the meeting itself may not be compensable, but the deliverable coming out of it certainly could be.
Good. I think we've addressed it. I think Julie was asking something about scope and the importance of beginning with the end in mind. The key to that is having clearly defined deliverables contained in the scope and the requirements documentation. That will provide the basis for acceptance, and invoicing for payment is clearly defining and beginning with the end in mind. That's a good point, Julie. Thanks.
Yes, the scope, it's particularly, I do, a lot of my work is business litigation. A lot of my work is construction related, all different types of disputes. Speaking in the context of construction, I can tell you that the scope of work is critical. I can't tell you how many times I've had cases where a party said that's not in my scope, another party says it's not in my scope, and sometimes it's not in anybody's scope, believe it or not. Nobody had the scope to do X and Y and Z, and so I would implore you to really look at what your scope is, whether it's construction, whether it's a piece of equipment, whether it's something having to do with a land deal, whatever it is, just make sure that you're as specific as possible on what the scope is going to be, so you're not arguing about it later. Because when you start arguing about it later, that's where, litigators love that. You spend a lot of time with a judge arguing about what the parties meant, or, lots of creative things that just all that does is drive up the costs. It's the nature of litigation when the parties aren't dutiful on the front end to get that done. And, a lot of times clients or folks in business, they don't want to spend, they don't want to necessarily spend money digging into the details of a contract, but I can tell you on the front end, but I can tell you that doing that on the front end is way less expensive than doing it on the back end. When you have to get a lawyer involved in trying to make arguments about something that should have or should not have been in the contract or in the scope or whatever it may be, it's very expensive. It's much more economical to just take your time on the front end and make sure you've got a good, tight contract than having to litigate what the parties meant years after the fact. The one thing that I didn't address that I think someone put in one of the questions was, someone said sometimes a conversation conveys ideas more quickly than email chains. Yes, I get that. But what I would suggest, as I did earlier in the presentation, is take the time to, you have that conversation. And I get it, the contract requires, John Jones to sign the change order, then it has to go to Sally Smith and she has to sign it for it to be binding. And if it doesn't have this and it doesn't have that, I get it that doesn't always work that way. A lot of times it doesn't. Just the project's moving fast and you can't get all the I's dotted and T's crossed. But have that conversation and follow it up with a quick email. Hey, good talking with you today. This is what we agreed to. This is what we're going to do. I can tell you, having been involved in enough of these cases where we're talking about changes to contracts, that takes a few minutes of your day. But I can tell you that it will take many, many hours, sometimes days, sometimes weeks to deal with in litigation, trying to prove up what the party agreed to on the phone, but nobody followed up with any writing. So just keep that in mind. And a little off topic, but when it comes to your email communication, probably goes without saying to most people, but I always tell folks, you write emails in business like you want a judge, or when a judge reads your emails, that judge would never make any commentary about whether it was inappropriate or so just keep those things in mind, because I've seen some pretty interesting emails in my career that just don't look good for the person who wrote them.
That's good advice. Thanks. Yeah. Any other questions? We've had a bunch of good ones. I'm going to pause and just see if there's any other questions. I think the COVID twist and or riots that affected some people's ability to do business in their area, I think those things are going to affect contracts. Mm-hmm. And I know in my line of business, it's often force majeure with the with hurricanes that came up. So that's where those come from. Yeah, what do you see?
I'm sorry, I didn't interrupt you there.
No, go for it.
I was going to say that the critical thing on those situations, or any delay related situation, you just need to understand what your contract says and make sure that you document it. It may be at the end of the day that someone doesn't agree that you're entitled to more time, or you're entitled to this argument regarding some sort of excuse, but don't miss your timing of providing that notice. Don't let someone argue to a judge that you had 5 days or 7 days or 48 hours or 72 hours, as are some of the more common timeframes that I see, and you had time to notify us of that claim and you didn't, and therefore you've waived and released it. So please pay attention to those notice requirements and make sure that you hit those just so no one can argue that you weren't timely with providing the notice looking for that type of relief.
Good point. Thank you. All right, folks. I think we have slowed in terms of questions unless anyone else has any verbally. Otherwise, I will turn it over to, I think, Amanda or Sue. I'm not sure who's taking over at the end here. I know there's a little.
I'll go ahead and close this out. Thank you so much,
you.
Rebecca.
Mm-hmm.
And thank you, Attorney Birr. I appreciate your time and the information that you've given us. Lots of food for thought here. And yeah, as I said before, we'll send the slides out either this evening or tomorrow. So keep your eye on your email for that link to download. There'll be PDFs of the slides. And yeah, if you've got any other questions, contact information is here on the screen still. And feel free to copy it down or grab it out of the slides when they get to you. And I think that does it for us. Thank you,
Thank
ladies
you.
and gentlemen.
I look forward to meeting everyone in person when we're able to do that.
Yes,
Someday.
sir.
Thank you.
Thank you.
Thank you. Have a great night.
Thank you for your presentation. Thank you very much.
You're welcome.
Connect with you all again next month. Looking forward to it.
Take care, Susan.
Thank you.
Bye-bye.
Amanda, do you want to stop recording?
Oh, yeah. Yeah, that's probably a good idea, huh?